right, today I'm going to answer the question, what does it take to file a design patent? Hi, I'm JD Houvener, owner and founder here at Bold Patents Law Firm, also the author of Bold Ideas, the Inventor's Guide to Patents. I've helped thousands of inventors over the years and over 500 patents issued. Let's dive into this question about design patents and what does it entail? How do you get that filed properly? Well, the first way is by after talking with an attorney and finding out your results from a patent search. That you decide, you know what, utility patent might be too hard, might be too challenging because you've got so much prior art. Maybe it's a busy area of innovation and trying to get just a very narrow sliver of a utility patent may not be worth it. And that's really a decision that can come from an opinion from an attorney saying, yes, we could probably get you a patent in this area, what you've created, but the scope of rights is quite narrow. And there is a risk, of course, the examiner will just shut it down and not allow anything through. But because you've made something physical or you have a graphical user interface in your software, that depiction, that three-dimensional article can be protected under design patents. So in a way, it's oftentimes a fallback, if you will, in terms of a secondary in the overall ranking order of patents that you want to own. A design patent is excellent and will provide 15 years of protection after the date of file. One cool aspect of design patents is that there's no maintenance fees owed after issuance. Another interesting fact about application-wise, it is really light. There's not pages and pages of written description about your invention. In fact, there's usually only one claim that talks about, hey, this is the ornamental depiction of your invention as shown and described. Well, there really no description. It really is just the figures, the 2D representation of your three-dimensional article of manufacture. Now, the drawings control everything. There's a lot to be said about patent drawings, especially design patent drawings. Now, you have to make sure that there are really clear definitions through the figures of how your product looks. Now, you can be creative in terms of what you're claiming. In the actual drawing, the solid lines of the design of the actual drawing in each figure, that's what the examiners will be looking at to see if there's anything else in prior art that would say this is not novel or that it's an obvious version based on the overall shape. Okay, you can put things in dashed lines if you're not claiming them, maybe if they're part of the environment or part of an associated structure that your product is involved with, or maybe reliant on in terms of how to get it positioned or how to make it in terms of the reality in the human world, how this product actually sits, or in the digital world within a graphical user interface, for example, how it might look on a screen. You're not likely going to be claiming the screen or any specific ways that it's featured, let's say on a TV or a nightstand in a room, but it's important to show where your graphical interface would fit in a device that is in the ordinary skill of the art. So know that the application process is quite simple and much more straightforward. Therefore, it's usually less complex and less expensive to work with an attorney to draft a design patent. Now, the prosecution, which is after you submit it, is a whole different story. And we'll save that for another video. But I hope this was enlightening about how design patents are not that big of a burden to file, and the application process is also straightforward. I'm JD Houvener, owner and founder here at Bold Patents Law Firm. Happy to answer your questions today and every day. Go big, go bold.